Ladies and gentlemen, I formally welcome you all with a very warm good afternoon. Today, I am taking our deliberations to the next stage where we are going to deliberate and discuss a framework for refugee status determination, or you may call it the framework for a refugee determination system. My dear friends, under this engagement of today, we are going to understand that there is a requirement of a well-designed model that is going to determine certain important facets which are indispensable to this such kind of framework. We have to understand there are certain important stages, there are certain important points which are required to understand a well-designed model for the determination of refugee status. Number one, such a model requires the methods of entry into the refugee determination system. Another important point, that is the circumstances in which asylum claims are made or accepted. Third important stage would be, or under this particular model framework, how and by whom claims will be assessed, and the pathways an application may take through this particular system. Therefore, my dear friends, these points, of course, important points, we have to understand these points within the rubrics of, within the mandate of 1951 UN Convention relating to the status of refugees. My dear friends, this refugee convention does not specify procedures for determining refugee status. United Nations High Commissioner for Refugees has recommended a number of elements based on international standards and practice. The very first understanding under this particular recommendation has been, designed to encapsulate certain important points. Therefore, we can say that the United Nations High Commissioner for Refugees has made this recommendation with a number of elements based on international standards and practice. Number one, my dear friends, we must take into account the number one element is registration and identification of asylum seekers. Number two, legal advice and representation. Number third, or the third element is opportunity to contact UNHCR. That must be taken into consideration. And the time to prepare the asylum request. Another important element that comes to my mind is personal interview with a qualified official. Then a decision rendered by a clearly designated authority. Thereafter, a process to reconsider cases where claims have been rejected. So that is another important, dimension. Another important, point is, that is the point number two, that the framework which I am, talking of, as I have, submitted at the very outset of today's engagement, that this model framework for status determination will involve the prevailing legal tradition in a particular geopolitical entity or state. Third important point, my dear friends, that comes to my mind is the nature of refugee determination system will also be influenced by certain important dimensions and internal dynamics, like existence of procedural safeguards under migration legislation in a particular, state or in a particular or a specific geopolitical entity. Another important, dynamic consideration that must also be taken into consideration is constitutional, domestic, or regional human rights provisions affecting rights of the due process. Then the entitlement to remain in a country during the process of refugee status determination. The fourth important element of this model framework for the determination of refugee status is that a few of the most important considerations for a system that determines refugee status and related appeals, and my dear friends, it also encapsulates, includes, number one, resources that are allocated to it, the capacity of the administrative infrastructure to process fluctuating number of applicants, then the ability to achieve and regulate a uniform approach so that there is equality of outcome in the similar or identical cases. Then the legal criteria used to determine protected reward status, and the approach, my dear friends, taken to assess an individual's eligibility for each type of, protected status. At the same time, my dear friends, it also involves a study of levels of internal administrative or external administrative appeal and judicial review that are available for the final determination of the merits of a particular claim for refugee status. Another important aspect that must not be forgotten, and that is the nature and level of status in terms of durations, in terms of benefits, in terms of other important entitlements to be granted to those who are being processed, whether national legislation or national practice treats the removal of failed asylum seekers and the deportation of non-asylum related cases differently. Whether lodging a review application or an appeal suspends the process of removal or deportation, whether to offer assistance that facilitates the reintegration of the failed asylum seekers into their country of origin. So here lies another important what we call, stage of this model framework for the determination of the refugee status is how to grant asylum. What are the, dimensions which are, involved in the granting of asylum? This is a very, very important point which I wanted to cover, but somehow I missed it in my previous what we call submissions when we were deliberating the idea of asylum. So granting of asylum constitute a very, very important what we call dimension, because incorporating international standards and practices into national legislation is particularly important in areas on which the Refugee Convention is silent. For example, procedure for determining refugee status. I can cite another important, article from the, convention, and that is Article 31 of the UN Convention relating to the status of refugees of 1951. And it applies to asylum seekers since some of them are in the fact refugees who have not yet been recognized by the competent authority in the, reception, country. And this reminds me of a very, very important, decision, my dear friends. Though the decision has been delivered ex parte in 1999, it is R versus UX Bliss Magistrates Courts and another. And this is a decision which has been delivered by the England and Wales High Court, particularly the administrative side of the, High Court. The purpose of Article 31 of 1951 convention, refugee convention, my dear friends, it has been what we call critically appreciated by the England and Wales High Court in its administrative side, is to provide immunity for genuine what we call refugees whose quest for asylum reasonably involved a breach of the law, whether the illegal entry or use of false documents or delay could be attributed to a bona fide what we call desire to seek asylum, then that of conduct should be covered under article or by article 31 of 1951 convention, because article 31, my dear friends, not only extended to those claiming asylum who were ultimately granted refugee status, but also to those claiming in good faith to enjoy the protection of Article 31 of 1951 Convention relating to the status of refugee, a refugee must have come directly from the country of his what he call persecution, presented himself to the authorities without a delay, and have shown good what he call cause for his illegal entry or what he call persons in the country of reception. A short stop en route to an intended sanctuary could not forfeit the provisions as well as the mandate which has been given and provided under Article 31. So therefore we can say there is a general view that asylum seekers should not normally be detained, as we have already what we call you might have studied Snowden's decision, not Snowden's case in Moscow, at Moscow airport. Long back I have written an article on that particular controversy. So that is in public domain. So you can Google and you can study what exactly and what happened to the international rule of law on this particular point. Therefore, we can say, my dear friends, that asylum seekers may be detained for a number of reasons, as long as these are clearly based on national legislation that conforms to international human rights law as well as international human rights treaty obligations. The detention is permitted by way of exceptions in order to, there are certain important riders, there are certain important safeguards, there are certain important human rights induced shields which have become the basis under international human rights law as well. So therefore, if any kind of a detention that conforms to these very standards, to these kinds of what we call of riders and conditions, then in such limited what we call dimensions, detention may be critically appreciated, and it may be permitted, but it cannot be what we call very comprehensively permitted. It is permitted due to certain important dimensions like verification of identity in cases in which identity may be to undermined or may be undermined or in dispute. Determine, detention may also be permitted in a situation where determining the elements on which the claim for asylum is based. In situations where we are going to deal with cases where asylum seekers have destroyed their travel or identity documents or have used fraudulent documents, in such a situations, detention may be permitted. At the same time, in a situations where the protection of national security is of vital importance and maintenance of the public order, that the alternative to detention is also there, that a state may wish to consider include imposition of monitoring requirements. That is another a kind of alternative to detention. Then the provisions of a guarantor or surety, release from detention subject to the provisions of the recognizance or recognizance, I should say, and surety. Another important alternative to detention may also be contemplated, like requiring the asylum seekers to reside at a collective accommodation center. Then in such a situation, my dear friends, if these dimensions are satisfied or not satisfied, then there is another important alternative, and that is what we call the idea to develop solutions for the refugee protection. And one of the most important what we call idea that comes to my mind is the concept of temporary protection. Though at a later stage a full-fledged deliberation would take place on the idea of temporary protection, but in this context, the context of how to determine refugee status, temporary protection also constitute a very, very important dimension. Temporary protection, my dear friends, is an immediate short-term response when large number of people arrive after fleeing armed conflict, massive violations of human rights, or other forms of what we call of persecution. The basic and the most fundamental objective of the temporary protection is to ensure protection in the frontline countries of asylum or elsewhere, as well as to provide a coherent regional response to people who are fleeing what we call persecution or the territories of dangers. The countries of asylum, therefore, may end temporary protection when there is a fundamental change in the circumstances that prompted people to flee or to leave their country of origin. The countries of asylum, my dear friends, should take care not to push for premature, returns, since that can destabilize the home country. The countries of asylum must identify and protect, persons who cannot return to their, home countries or country of origin. So therefore, there is a, requirement, or there is a, alternative of temporary protection. But there are, my dear friends, even beyond, temporary protection, there is a requirement to have some kind of an emergency responses. So what are those very, situations, and how to appreciate on the critical footing before, going for determination of the refugee status? There is a, requirement, or there may be situations where the emergency response becomes inevitable. So what do we mean by emergency response? My dear friends, United Nations High Commissioner's, working definition of the refugee emergency is any situation in which the life or well-being of the refugee will be threatened unless immediate and appropriate action is taken, and which demands an extraordinary response and exceptional, what you call, measures. So this is how somehow like this, the emergency response designed for the protection of refugees has been what we call, designed by the, by the United Nations High Commissioner for Refugees. Because the refugee emergencies are times of, crisis for the refugees, and often for the country of asylum, which may be under tremendous as well as the horrendous, rather, pressure. The aim of the emergency response is to provide protection and ensure that the necessary assistance reaches the people in time. Therefore, the country of asylum is responsible for the safety, assistance, and law and order requirements for refugees on its territory. When the circumstances under which large number of people flee indicate that the members of the group could be considered individually as refugees, it makes sense for the country of asylum to use prima facie or group status determination whenever this kind of exercise, which is popularly known as the RSD exercise, refugee status determination exercise, that is generally resorted to. The governments often, my dear friends, rely on the international community to help share the financial burden of emergencies, whether it is disaster emergency, whether it is seismological emergency, hexicological emergency, or environmental emergency, or climate change induced emergency, or armed conflict emergency. There has always been a convention as well as a tradition among the nations who claim themselves to be the civilized nations, or the entire membership of the United Nations organizations. So they have been talking of international solidarity, international what we call idea of responsibility sharing. It has been further strengthened by adopting global compacts in 2018. So, but prior to that, even there has always been a tradition, there has always been custom, a customary practice to offer or to extend help and support during humanitarian crisis in any geopolitical entity. So agreements that divide responsibilities, emergencies, help to avoid duplication of effort and close gaps in assistance. And therefore, if you take into account the recent disasters, seismological emergencies, or the emergencies or humanitarian crisis that was caused in Turkey and Syria because of the what we call earthquake. So entire world, entire what we call community of nation states stood up, and they have offered, including majority of the South Asian nation states, including India. So we have been at the forefront in offering our services. Same is the situation with that of refugee crisis. So it is the responsibility of the international community to save and to what we call contribute in what we call salvaging these kinds of what we call of emergencies. Therefore, the Executive Committee of the United Nations High Commissioner for Refugees has agreed to a set of internationally recognized basic standards of treatment applicable in refugee emergencies. And my dear friends, these international I mean, standards for a comprehensive or across the board treatment of what we call of, refugees have been, identified. Number one, what we call, standard. I mean, standard of, treatment that is, relating to, and that, ensures the borders are kept open to allow access to safety. There should be an adoption, an expansion of the refugee definition that is, found on the basis of the element of complementarity that I have been from the day one, arguing and advocating, and which is generally found in the OAU Convention, or including what we call, Cartagena Declaration that has been designed exclusively for the Latin American nation states in 1984. So that should also be taken into consideration. It's international, standards and well-recognized what we call, standards of treatment applicable in refugee emergencies also include, my dear friends, the idea of temporary protection whenever it is required. It must also, provide, protection to victims of war who do not meet the Refugee Convention definition. There must also be the international support and responsibility sharing, as I have already submitted, including the international solidarity with the, people, with the, nation states who are flooded or who are, confronting or facing a situation known as the refugee influx, including what we call the durable solutions must also be, found out. Because for the vast majority of the world's refugees, the preferred solution is to return to their home country through voluntary repatriation. Both voluntary repatriation and local integration are durable solutions for refugees. A third durable solution, as I have already submitted in my previous, submissions, available to only a very small percentage of refugees, and that is the resettlement to a second country of asylum or the third country of asylum. So if you take into account, my dear friends, and how to understand this whole idea of, durable solutions, it is important at this stage that I must what we call, clarify on certain specific, dimensions. Suppose take the example, what do we mean by voluntary repatriation? My dear friends, voluntary repatriation is the preferred solution of the majority of the refugees, because nobody wants to be a refugee. Everybody is willing to return to their country of origin. Therefore, the United Nations High Commissioner for Refugees requires a certain level of physical, legal, and material safety before actively, promoting voluntary repatriation. There are, certain important, ideal scenario, or in the ideal what we call, scenarios, my dear friends, conflict has ceased and threats to physical security have been removed. In such a situation, voluntary repatriation becomes a possibility. Second scenario is refugees make a free decision to return based on full knowledge of the conditions in their home country or country of origin. That is another important ideal scenario. The status of returning refugees is assured through a tripartite agreement between UNHCR, the country of asylum, and the home country. That is another important scenario. There is another important scenario, my dear friends, of the gaps between the relief phase of the operations and the longer term development assistance have been bridged. In such a situation, it facilitates, my dear friends, this kind of a scenario facilitates some kind of a return or voluntary repatriation of refugees to their country of origin. There are, in addition to these ideal scenarios, there are some realistic scenarios as well. The protection offered and the assistance available to a country of asylum are insufficient in terms of what we call the realistic scenarios. Another important realistic scenario which that comes to my mind is that refugees must choose between the lesser of the two evils and often opt to return home in the hope that the conditions might have improved during their absence. That should also be taken into consideration. Another important scenario, or one of the durable solutions, is local integration. My dear friends, when we are talking of the local integration of refugees in the country of reception or country of asylum, then the local integration should be understood as it refers to assimilation into new national communities. 1951 Refugee Convention provides that the state shall, as far as possible, my dear friends, facilitate the assimilation and naturalization of refugees. But in recent years, my dear friends, fewer countries have felt themselves to be in a position to offer local integration. Although there are some notable exceptions, for example, Mexico's naturalizations of thousands of refugees from Guatemala. So on this particular point, so far the local integration is concerned, I find Mexican government very liberal on this particular point. Another important durable solutions, which is popularly known as resettlement. My dear friends, the refugees, in the context of resettlement, refugees primarily at risk in their country of first asylum, when we are talking of the resettlement in the second country or in the third country, for whom there is no other durable solutions to their plight, have protection needs that can be best met through considerations for the resettlement. For many refugees, resettlement is in fact the best or perhaps only alternative available for their safety. Priority under all circumstances, my dear, should be given to those refugees with acute legal and physical protection requirements. Therefore, in order to be recommended for resettlement, refugees must meet United Nations High Commissioner for Refugees criteria and must also be accepted under the criteria of the resettlement country. There has to be some kind of a consensus between the country of what we call reception of refugees and the country of what we call resettlement. Certain countries regularly offer resettlement spaces. Others do this on an ad hoc basis. Most resettlement countries generally prefer, my dear friends, educated refugees with strong family and cultural links to the resettlement country. And suppose, for example, the countries like United States of America, countries like what we call Canada, countries like Australia, an intact family structure they generally promote. If there happens to be an intact family structure, then the such refugees, in the name of the family reunification, they generally prefer and they offer their services as integrating refugees or resettling refugees in the third country. We find at the same time, my dear friends, a high likelihood of the rapid integration. Non-governmental organizations play a very, very important role in such kind of situations. Very significant role has been identified. Under these kinds of involvements on the part of what we call of the non-governmental organizations, these non-governmental organizations have been providing various resettlement services. In countries of asylum, suppose NGOs help counsel and assist refugees who may be eligible for resettlement. In resettlement countries, non-governmental organizations are the primary providers of services to the arriving what we call refugees. Asylum seekers are subject to a variety of what we call procedures, examining their individual reasons for being outside their country of origin and determining their refugee status. All such kind of situations are generally handled by the non-governmental organizations who have dedicated their entire what we call life in the service of what we call of refugee protection. Therefore, RSD procedures or the refugee status determination procedures within states can vary based upon location, country of origin, personal what we call history of the refugees. Despite recent efforts to harmonize, my dear friends, refugee status determination procedure, there is still no single model for RSD in Europe and elsewhere, including what we call South Asia, that makes RSD an imperfect, absurd, and challenging what we call process. So we do not have any kind of stability in this, or any kind of continuity or perpetuity in this kind of mechanism, which is popularly known as RSD mechanism. My dear friends, in RSD mechanism, or in RSD what we call, there remains troubling what we call variations in outcomes in similar what we call cases. For example, the acceptance rates for Iraqi refugees in European states governed by the European Union's RSD standards varied between 0% in Greece and 81% in Sweden. If you take into account the fluctuating data since what we call Iraq war. The studies of the outcomes in refugee status determination procedures have linked recognition rates to a variety of what we call seemingly extraneous factors, including government ideology, country of, asylum demographics, and the number of, refugees already in the country of asylum. The recent studies, my dear friends, in Canada and the US have shown that the identity of the decision makers in refugee status determination is often the most significant influence on such kind of, outcomes. The recognition, particularly the recognition rates, have also been linked to the refugee movements with higher what we call recognition rates, prompting future population movements. Even factoring in successes upon appeals and grants of, complementary protection, a majority of the, asylum seekers worldwide were what we call, refused any sort of, protection. And this kind of a, denial, my dear friends, this kind of a, refusal constitutes, if you take into account the entire, population of refugees who have been deprived of any kind of a refugee protection by the national, governments and their RSD, mechanisms and systems, such kind of a, refugee population constitutes almost, 55% of the total, population of refugees. So it's a very significant amount of what we call of, deprivation, because the high rejection rates and consequent threats of the, forced removal from the countries of asylum make these issues of vital concerns to asylum seekers and to the international community or in community of nation states. There are many issues, therefore, many issues in this particular, debate and discourse relating to the refugee status determination. There are three broad interrelated what we call, issues that cut across the national jurisdictions. If you take into account this, access to counsel, increasing transnationality of refugee status determination, and current governance of the international, refugee regime, that should also be, taken. If you take into account the very first element, that is access to counsel. My dear friends, Executive Committee of the United Nations High Commissioner for Refugees has recommended that the appellant should be given the necessity and the required facilities, including the services of a competent, interpreter. But whether this, competent interpreter is available, under what circumstances an interpreter has been what we call, provided, but at the same time, it is also, required that the interpreter be allowed to contact representatives of the United Nations High Commissioner for Refugees for refugee status determination framework, having regard to the full understanding of the facts of the case and on international law. Whether such kind of a, privilege is available to a person who has been entrusted with the responsibility of, contacting the representatives of, or the, RSD officials appointed by the United Nations High Commissioner for Refugees, or whether he is going to what we call, advocate, or would be able to understand each and everything in the language of the, refugee. Whereas Executive Committee, if you take into account the EXCOM conclusions or the Executive Committee, conclusions, are conspicuously silent on one particular issue. And the issue is access of asylum seekers to legal advice. So we do not have any kind of a, access. It is very, very important. But normally, if we are going to have some kind of a liberal interpretation of international law, then definitely, and that too in the light of the international human rights law obligations, my dear friends, it is incumbent upon the government as well as the United Nations High Commissioner for Refugees, agencies and services, that they must what we call, appoint a legal counsel. These kinds of, services have become the part of the civilized what we call, world order when we are, talking of human rights obligations of various, nation states. There is another important, dimension after access to counsel, which another important, point which I have, raised, that is the, transnationality of refugee status determination. I'm sorry, I'm giving some respite to my throat. You should also enjoy at your respective rooms some coffee or tea. It is important. for such a long engagement. Dear friends, transnationality of refugee status of determination basically and fundamentally conveys that the refugee law is inherently transnational in subject matter. That also reflects a more dynamic form of transnationalism. My dear friends, norms developed and elucidated in one jurisdiction are transferred to another jurisdiction. Courts or the judicial system in one country seek guidance from the jurisprudences as well as the jurisdictions of other, geopolitical entities. In the contemporary scenario or in the modern world, advocates must keep themselves up to date on developments in not just a single jurisdiction, but in multiple jurisdictions. This problem is not an abstraction, but presents itself every day when a client from country A applies to counsel in country B, who received a legal training in country C, hoping for resettlement to country D. Therefore, unfortunately, legal education currently provides too little training to refugee law, let alone with respect to its transnationality. And I hope, and this is my legitimate expectations from all of you, that as a student, including myself, as a student of international refugee law, we would be more forthcoming in terms of providing transnationality, facilitating refugee status of determination after passing out of this great seat of learning, that is SAU. So you are going to be one of the stakeholders by attending these kinds of dimensions, because this reminds me of a very, very important example from Bangladesh. One of your seniors, prior to the lockdown, prior to the arrival of COVID-19, one student appeared who accomplished his master's in international relations, who appeared on Bangladesh television as a refugee law expert. And he attended most of the questions from the panel discussions from the audience. So you can understand, my dear friends, what is the importance of studying this kind of a optional subject called international refugee law. So you should be aware of all the dynamics, how to determine the refugee status and determination. As I have already submitted, that there is no what we call uniformity in terms of the RSD mechanism. Each and every geopolitical entity have designed their own RSD mechanisms, but these mechanisms must conform to the dictate of what we call of international human rights, what we call obligations, including the mandate whether they are a party to 1951 convention or not, but they must conform to certain fundamental principles of a human right or international human rights law character. Therefore, my dear friends, this poses another important dimensions, and that is international refugee regime governance. Because if you take into account this international refugee regime governance, then we find the refugee status determination is one of the most important aspects, or one of the parts of this entire refugee regime governance. My dear friends, the governance of refugee law currently resides with the United Nations High Commissioner for Refugees under Article 35 of 1951 Convention relating to the status of refugees, with its additional protocol of 1967. UNHCR must both develop refugee law, attempt to secure its application by states and apply in its own RSD operations. That ensures, my dear friends, the refugee regime governance, the independence of UNHCR's interpretations of the Refugee Convention in RSD decisions cannot be guaranteed. UNHCR generally does not provide written reasons for its decisions in RSD, nor does it always disclose all the evidences upon which it bases generally its own decisions. Therefore, UNHCR policy making process all too often opaque, whereas UNHCR has to address the deficiencies of an international agency with legal immunity making such kind of decisions. Therefore, we can say, my dear friends, that the international refugee regime requires a reform that in turn requires a dialogue, and dialogue requires partners. Trained refugee council, aware of educated about their transnational positions and subject matter, can be one important partner. What is vital to the process is the inclusion of the voices of refugees themselves, as they are the most important partner and the most important party in all RSD proceedings. But to what extent these agencies, including what we call the United Nations High Commissioner for Refugees, have been able to what we call integrate the voices of refugees, because this is a new kind of a dimension that has emerged in the last more than what we call 15 years. Because what we have been witnessing, the peace activism by refugees. Refugees are going to be on many occasions have been integrated in the decision making process. In majority of the European nation states, my dear friends, there are NGOs who have been established by the refugees themselves, and they have been what we call arguing their own concerns, and that is why they have also become the part of the decision making process, the decision which are going to affect the lives and the future of refugees in a geopolitical entity. Therefore, it has become necessary on the part of what we call of refugees that they must voice. And this kind of a voice has also been advocated in the form of what we call of their contributions. And these contributions have been made possible because of the certain important rights which have been provided in the convention itself, and that is 1951 convention. So therefore, if I am supposed to conclude or having some kind of a conclusion, but in higher education, my dear friends, there is no conclusion. It is always open-ended. Tomorrow, on the same what we call line of argument, I can deliberate with a different flavor of language. But if at all there is a requirement of how to what we call give some kind of a conclusive or inconclusive what we call submissions, then we must not forget, my dear friends, the protection is not just a matter of rules and guidelines and handbooks. Similarly, it is applicable in case of the refugee status and determination mechanism. Protection is also about, my dear friends, it is about, the protection is about culture as much as an internal as an external matter. Against the background of the principle, whether it be the statutory, constitutional, or constitutional framework provided by the UNHCR statutes, or the wealth of human rights and refugee law, a measure of flexibility will always be required in the face of individual political and humanitarian nuances of successive crises, including the latest Ukrainian refugee crisis. It is as necessary to ensure that the dead hand of the legalist does not dominate, and it is to maintain consistency and adherence, my dear friends, to the principle of non-refoulement. A culture of protection is thus not just lawyers' business, On the contrary, while it supposes recognition here of an international legal context and commitment to principle of non-refoulement, protection is and ought to be on the basis of everyone involved. When we are talking of protection to refugees, my dear friends, it is about cooperation and working together. It is about listening to refugee and host communities. It is about learning and information. It is about saying no. This is not acceptable. When we are talking of the external mechanisms to ensure accountability, may now be needed both in fiscal terms and in relations to the mandate of the international protection. And this reminds me, my dear friends, Article 35 of the 1951 UN Convention relating to the status of refugees, and that does not go far enough to secure state compliance, while the UNHCR Executive Committee itself is not what we call suited either to the overview of the state actions or to determining UNHCR's accountability to mandate. And independent mechanisms perhaps founded initially on a regional basis and complement, as well as what we call competent to monitor and evaluate refugee protection from both legal and institutional what we call perspectives, may be just what we call what is needed to strengthen international law and the processes of the United Nations reform. Therefore, my dear friends, to protect implies either to provide a physical shelter or to use legal authority to secure the rights and freedom of what we call of those who happen to be at risk. Except within limited what we call circumstances. The first is generally ruled out. The second option, though, has a long history and a firm legal and the institutional what we call base. And to provide, my dear friends, international protection means first to insist on the fulfillment of the international human rights treaty-based obligations, customary international law-based obligations. And secondly, it has a practical aspect. It means being there and using all available mechanisms to provide international protection, including what we call the municipal law, governmental and non-governmental institutions, the impact of information, regional and international supervisory mechanisms, protest, each and everything is included. And thirdly, my dear friends, as if that were not enough, it means maintaining the humanitarian and non-political character of the work of the UNHCR. But of late, ever since we have adopted in the month of September in 2016, my dear friends, when we have adopted under the active supervisions of the Obama administration on one side, because for the first time the political character and the political nature of the global refugee crisis has also been accepted, and ultimately in 2018 the global compacts came into existence on refugees and migration. Therefore, the art of protection resides precisely in the ability to be flexible while remaining close by and faithful to the core of fundamental principles of knowing when not to compromise, and that should never be construed as a burden. So that should also be taken into consideration. Yesterday, on this particular point, I have also submitted and I have requested as well to one of the students, Mr. Sagar Verma, that you have to remind me what has been a critique of what we call of this entire mechanism when we are talking of international refugee regime governance. How to handle this kind of a understanding that has to be taken into consideration. When we are talking of international refugee protection regime or international refugee governance, then my dear friends, interactions with conversations about refugees and migration were dominated by Western experts, by Western or Occidental scholarship, who had never experienced forced what we call displacement, who lived thousands of kilometers away from where the political repression, conflicts, and human rights violations have taken place that drive people from their homes actually take place. My dear friends, these experts these Western or Occidental scholarship have been able to define our experiences and make policies about what happens with our lives, while people like me, people like you, have been blocked from the rooms where decisions are made. This is a fact. And this fact is not what we call unintentional. It is a product of how the global protection system for refugees was primarily formulated, calibrated, and designed. So therefore, if you take into account the genesis and the origins of this refugee protection regime governance, my dear friends, it has to be identified when this particular convention, 1951 UN convention relating to the status of refugees, was under drafting mechanisms. When the drafting was going on at that point of a time, what exactly happened, that must also be taken into consideration. Because when we are talking of refugee protection or the determination of the refugee status, my dear friends, I generally feel extremely flabbergasted and disturbed. There are certain important reasons, and these reasons I must share with all of you. Intellectually, you are supposed to enjoy your full liberty of disagreement, liberty of coming out with alternative views. Because what I have been contemplating, that if you take into account the entire institutional framework that has been created in the name of international law, in the name of pluralism, in the name of multilateralism, in the name of customary international law, in the name of constitutionalism, in the name of transformative constitutionalism, and today in the name of the digital constitutionalism or algorithmic constitutionalism, these institutions have become the subject matter, have become the oppressive instruments in the hands of what we call of global north jurisdictions to subjugate, to suppress their counterparts located in global south, what we call trajectory of geography. Similar is the case, my dear friends, with United Nations High Commissioner for Refugees as an institution. If you take the study, my dear friends, of the United Nations conference that was convened to draft the 1951 Refugee Convention, the failure of countries to provide safe haven to people being persecuted and killed by Nazi Germany during Second World War was the main catalyst behind this particular international, so-called international endeavor. When I was studying these proceedings of drafting, and I still feel that I have not make myself adequately and sufficiently informed regarding the circumstances, articulations, oratories, perceptions, which have been navigated and ventilated by the stakeholders during the drafting of 1951 convention. Despite everything, my dear friends, I felt stunned to see how dehumanizing and racist the discussion had been. It is immensely, dehumanizing and demonizing. I was going through the observations of the one civil society scholar, and he was of the view, my dear friends, that one might easily have gathered the impression that the average refugee was a black, marketeer in currency, a bankrupt, a dangerous, what he call, criminal, an enemy agent, a menace to the labor market, and a person unfit for higher education. These were the words, my dear friends, of those people who took upon themselves the responsibility of, crafting a Eurocentric document which is today known as 1951 UN Convention relating to the status of refugees. This has been the mindset, my dear friends, almost 75 years ago. That was the, perception about what we call, refugee protection, or about, refugees. In other words, we can say, many of the delegates who created this kind of a, international refugee protection regime, international refugee protection architecture, exclusively designed for the global protection or emplacing a global protection, system, viewed refugees as economic and security threats. A problematic perception. A problematic perception that continues to dominate narratives about forcibly displaced people even today. So, my dear friends, how should we view? Or in other words, who were these, delegates? Who were these, people who have, become the masters of a humanity that happens to be on the move? At the time, my dear friends, when the Refugee Convention was being drafted, you would be surprised to know that there were, if you take into account the entire membership of the United Nations organization, I put this question to you, what was the membership at that point of time? My dear friends, only 60 UN member states compared to the today's what we call 193 or 96 nation states. This was the membership of the United Nations organization at that point of a time when this particular Eurocentric convention was under drafting. Many countries in Africa, Asia, Caribbean, and the Pacific were still colonized. Global North countries, my dear friends, wielded outsized what we call larger than life what we call influence on the drafting of the convention. And this reminds me of a very, very important scholar, Ulrich Krause, who happened to be a researcher and a professor of the post-migration and refugee studies, who adumbrated all these circumstances. And the result was a decision only to extend UN refugee protection to people displaced within Europe prior to 1951. As I have already submitted to you, that there has been a geopolitically what we call demarcation, a deadline, a limitation date that was contemplated. Key framers of the Refugee Convention, my dear friends, including the United States, France, and Italy, did not want to forcibly displace people from recently partitioned India and Pakistan, or the people displaced out of the partition of the Indian subcontinent, Middle East, and elsewhere, reaching their borders and claiming any kind of a refugee protection. So the drafters were carrying the garbage of racism in their minds. So this was the position. This was the mindset. This was the attitude towards the humanity of the people hailing from the global South nation states. In this context, therefore, my dear friends, and particularly in the context of what we call of the latest refugee crisis emanating from Ukraine, what we have been seeing and what is possible when all actors come together to respond to forcibly displaced community with dignity and respect for their human rights. Is it the correct kind of response? And it is one that all refugees, regardless of our or their race, ethnicity, gender, class, political opinion, should receive. But the political masters of many geopolitical entities have not been what we call sincere. And what is important, if you take into account, my dear friends, it is the art of interpretation. The art of interpretation that has been resorted by the community of nation states and their what we call agents and agencies. In each and every stage of the human evolution, there have been people and experts and scholars who primarily discarded and disdained the human values. And the drafting of 1951 convention is not an exception. If you take into account the grounds which have been adumbrated and incorporated in Article 1, and these are the grounds, as many as 5 important grounds have been identified by the framers of the 1951 convention. Basically, these were not only the grounds, but in my understanding as a student of international refugee law, I perceive them as human equalizers. Because we have to attain equality. Equality in humanity. When we are talking of humanity, when we are talking of dignity, then we are talking of fraternity, when we are talking of liberty, what is most important pervading line of argument, the pervading line of argument, and that has been pervading in these what we call principles, is the idea of equity and equality. This idea of equality must under all circumstances impregnate the idea of humanity. But this was something that was missed out. It has not been implemented, despite the fact, because the wrong interpretation has been what we call visited by many of the what we call people. Therefore, another important scholar that comes to my mind on this particular issue is, in 1975 or 76, my dear friends, one author, Toni Morrison, rightly pointed out that the very serious function of racism is distraction. Because racism keeps you from doing your work. Racism keeps you explaining over and over again your reasons for being racist. Systematically marginalized communities in global north, jurisdictions, my dear friends, including forcibly displaced, what we call, people, find themselves having to play the role of educator over and over again to explain factual, highly documented, systematic injustices like the one which I have, submitted for your perusal, for your consideration, in the name of what we call of racism. Because racism has always been rampant in refugee protection. Discriminatory practices, well organized, well patronized by the state institutions and state sympathetic actors, or state sponsored, what we call, actors. And they have always, promoted this kind of a, segregation of people exclusively on the basis of racism and xenophobia. So this particular, sector of the refugee protection, my dear friends, requires grassroots movements where refugees and allies can build trust and reconciliation through acknowledgement and accountability about past wrongs and how the international refugee governance regime currently, what we call, functions. There is a need for a movement, my dear friends, where refugees led the way. They should be the masters of their own destiny. They must, what we call, ensure that they are not taking power and agency away from people in the name of empowering them. Rather, the empowerment of refugees must ensure that their voices are likely to be integrated in the decision-making process. Then only we can have some kind of a, universally accepted, what we call, idea of refugee status determination procedure, which is what we call, functioning, which is going to be viable, receptible, and at the same time, in conformity, incommensurate with that of the international human rights law and other, treaty obligations, including customary international law norms. Thank you very much for the day. Any questions? Session is open for your questions. If you have any questions, you're most welcome. I have identified a few thematic books as well, which have been recently contributed. And these books have been addressing refugee status determination procedures. So I intend to share, but not for your examination, exclusively for your further advancement in the area of international refugee law, for doing any sort of, research or writing research papers after, passing out. I intend to share. So I will share. So see you, my dear friends, in this week. There is a possibility I may request you, or all of a sudden you may also have a link. Please keep on checking your inboxes. I may organize with the prior, what you call, request that I am making today. I may organize another important, evening engagement with all of you, either on Friday or Thursday. So thank you very much.
Thank you, sir.
Thank you. Thank you very much.
Sir.
Thank you very much. Bye-bye. Take care. Thanks a lot for being with me. Stay blessed. Thank you.